All right, the court is calling 2022 CR 8531 State of Texas versus Ernest Aldorete. Can I have parties announced for the record for the state,
Brian Grimmer for the state of Texas.
for the defense?
Kathy Compton from Mr. Aggravated.
And are you Mr. Aldorete?
Yes, ma'am.
All right, counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, I have.
Court will find that the state is in compliance with discovery. Mr. Aldorete, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, we do.
State, are you proceeding on the indictment as presented?
Judge, we're waiving one of the two repeater enhancement allegations. I don't know if it's notated in the plea paperwork, which one.
Let's see.
I believe it was the second one. If I
Second one.
remember correctly.
Yes, it appears that the second one is being waived.
We'd waive the second enhancement allegation, Judge, and proceed on the first enhancement allegation, making this a first degree felony.
Any objection?
No objection.
All right, Mr. Aldorete, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it, and did you sign it in all the appropriate places?
Yes, Your Honor.
All right, did you understand you're charged with aggravated assault with a deadly weapon? Normally, the range of punishment of that offense is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Do you understand?
Yes.
If the state is able to prove that you've been previously convicted to another offense, then the range of punishment will be that of a first degree felony, and that range will be anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes.
Did you understand if you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement? If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
We've discussed the case, and yes, we've discussed possible defenses.
Right. Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Aldorete, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea bargain agreement?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain agreement, did you review that with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, you would agree that you've been previously convicted to one felony for enhancement purposes. Punishments be assessed at 15 years in prison. There's an affirmative finding of deadly weapon and no applications. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
It is.
State, is that the plea?
It is, Judge.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it, and did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there been any such motions?
No.
Then to the offense as charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
Yes, Judge. State would offer state's exhibit number 1.
No objection.
Mr. Aldorete, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it, and did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. With regards to the enhancement allegation, I need to know if it's true or not true. It states, and it is further presented in and to said court, that before the commission of the offense alleged above, hereinafter styled the primary offense on the 27th of April AD 2005 and cause number 2005 CR 3244W in Bear County, Texas. The defendant was convicted of the felony of robbery. Is that true or not true?
True.
Court will review states exhibits 1 and attachments. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will find you guilty. The court will find the enhancement true based upon states exhibits 1 and attachments in your plea of true. Are you proceeding with sentencing?
We're asking to do so.
Anything you wish to say on behalf of your client?
Your Honor, I just ask that you follow the plea bargain agreement.
All right, the court will follow your agreement, sentence you to 15 years in the prison, give you credit for any time served. There's an affirmative finding of a deadly weapon. I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, and because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You do understand?
Yes.
All right, Mr. Aldorete, good luck to you, okay? Try to do better.
Thank you. I will.
All right. All right, anyone else ready?
This case concludes with the court accepting the plea agreement and sentencing Ernest Aldorete to 15 years in prison for aggravated assault with a deadly weapon. The judge also found the enhancement allegation to be true, meaning the defendant's prior felony history played a substantial role in determining the punishment range available to the court. Additionally, the court entered an affirmative deadly weapon finding and confirmed that the defendant waived his right to appeal as part of the plea bargain process. From a legal perspective, this hearing demonstrates how plea agreements operate within the criminal justice system. While trials often receive the most public attention, the overwhelming majority of criminal cases are resolved through negotiated pleas. These proceedings may appear straightforward, but they involve significant constitutional rights, careful judicial review, and life-changing consequences for everyone involved. The broader takeaway is that prior criminal history can dramatically alter sentencing exposure, and decisions made during plea negotiations can shape the final outcome long before a defendant ever stands before a judge. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.